So David, I think we're ready to get started with this webinar, especially for our friends at the St. Louis ILG.
Really great to be here with everyone, and Nita, nice to see you again. Welcome to everyone. We're really glad to see people are jumping on right now. We can see as the little count meter rolls. So let's get started, because we have an hour, and I want to take and make really good use of everyone's really valuable time with you, because there's a ton of material to cover. My name is David Fortney, and with me is Nita Beecher, who you see there. Nita, you want to say hello?
Hi everyone. Nice to see you, and delighted to do this with David.
Yeah, we're both really excited to have a chance to talk to you a little bit about the types of things that we're seeing in terms of the federal government's response to the COVID-19 pandemic and the employer's concerns. And largely what we're trying to do is take what Nita and I pretty much are spending a large part of our days dealing with in terms of our clients, the types of issues, kind of the lessons learned from that we hope will be beneficial to all of you. So let's go to the next slide and cover a couple of preliminary things, and then we'll jump right into it. So next slide there, Valerie, please. Terrific. Just a brief note about who we are, and the purpose of today. The purpose of today is to give you general information, although both Nita and I are obviously attorneys. We are not your attorneys for purposes of this webinar, but is to provide you with information about specific legal developments and legal-related developments. That said, we would encourage each of you to secure advice from an attorney who is experienced in labor and employment matters about how your company's facts should be applied to these developments. Finally, just a quick note about Fortney Scott. We are a Washington, D.C. based law firm. We do represent exclusively employers in dealing with matters of the workplace. Our practice focuses on the federal agencies. Many of you focus on OFCCP. That is certainly one of our primary agencies, as well as other Labor Department agencies, the EEOC, the National Labor Relations Board, as well as other agencies and those developments. So with that, Nita, let's see if we can get to the agenda and talk a little bit about what we can cover today.
Absolutely. And before we get too far, I'd like to thank Alicia Turner-Robinson for inviting us to present today. Thank you very much, Alicia, and sending this around. Well, this is kind of what we're going to cover. We're going to give you an update on federal government action at this point. We're getting ready to expect some more. David will talk about that a little bit. Then we're going to walk through each of the agencies that we tend to work with the most. OSHA is going to be one that most of us don't spend that much time with generally, but now we will. EEOC, of course, NLRB. We're just going to touch on OFCCP because we had a very good presentation by the new regional director for OFCCP in the Midwest in Chicago. And finally, wage and hour, and we'll talk a little bit about some new regulations. Then Dave and I want to spend about 20 minutes or so walking through what we're seeing as the top issues as employers open. And naturally, for those of us in St. Louis, one of the issues we're going to talk about is Lake of the Ozarks. And so with that, Valerie, if we go to the next slide. So what's been happening the last week or so? And skipping to the next one. So the CDC has been providing guidance, which of course has now become somewhat more political than would be advisable in a situation like this. But nevertheless, right before Memorial Day, they issued quite a bit of guidance on cleaning and disinfecting workplaces, businesses, and so forth. They had 6 different sectors on how to do it. And one of the issues that also came up, which I'm not sure a lot of people think about, is a lot of these disinfectants have their own side effects. And so you have to be very careful when you do the cleaning and having a reputable person doing it, making sure that you're not going to end up with allergy issues with your employees or customers. It's sort of this fine balance between cleaning and disinfecting and then creating a potential hazard. There are lots of great flow charts talking about social distancing, hand washing, and so forth. And more of this can be found at the link that we provided here. It was a little bit more detailed guidance than had been provided up to this point, but I actually kind of like the next set of slides. Valerie, can we go to the next set? I found these small, they are one for various different workplaces. And I think for many employers, this is going to be a very easy way to kind of walk through, are you ready to reopen? I myself, being in St. Louis, actually was able to go to the Beauty Potter this weekend. But what they had done is a lot of the things you see on this slide. There was, you weren't allowed to come in until they took your temperature. You had to have a mask. They had a mask. For those of us who got manicures, you had a screen like you see at the Schnucks between you and the person giving you the manicure. And I think that is exactly what's required. You were required to use, wash your hands or use hand sanitizers before you came in and anytime you touched anything. So these are all, I think, very helpful. And social distancing, they had it set up so that you were farther, at least in addition to masks, you had 6 feet whenever possible. And I think this makes it easier for employers to walk through that. And then on top of, in these various diagrams, you can also click on and find the other information CDC has provided over the pandemic as far as cleaning, social distancing, signs and symptoms, and that type of thing. In a few minutes, we are going to talk a little bit more about OSHA and what's required as far as figuring out when you have to send people home and so forth. And so, David, do you want to talk?
One thing, Nita, that I thought this chart did a nice job of is helping everyone appreciate the level of preparation that needs to be thought about. It's not just, okay, we're going to reopen. Let's notify people and get them back in. There is a lot, and these charts, they're not meant necessarily to read just so you have a graphic of it, but we would really encourage you, we've given you the website link, go there and spend some time, you and the appropriate team, in appreciating, as we say, the workplace you go back to is not going to resemble in many significant ways the one you left in the middle of March. And that point is one that really is driven home, I think, on this chart pretty effectively.
And one thing they don't really have on this chart, David, but one thing we've talked about, and we'll talk about a little bit more, is what are you going to do in those situations where you have a, so for example, talking about the DC office, which they're not as far along, so you all haven't opened yet, but coffee service, refrigerators, bathrooms, elevators, and in fact, we've seen some pictures, for example, of basically 2 people in an elevator going up, which in New York City, of course, would be a disaster. That kind of level of detail has to be thought through before offices open.
Exactly right. No, it's very, very intense.
So going to the next slide, and David, I'm going to hand over to you the latest from Congress in trying to provide the next round of relief.
Sure. So shortly before Memorial Day, right on the eve of Memorial Day weekend, the House of Representatives came back into D.C., even though D.C. is on a lockdown. Nonetheless, the House did meet and practice some social distancing in doing that. And ultimately, the House passed the what would be the next round of stimulus funding, so-called the HEROES Act, and it provides $3 trillion in additional funding. The key thing here is that although it's close, it wasn't a perfect party line vote, but this was clearly kind of the beginning of negotiations. And Speaker Pelosi made that clear. She said, look, we've got to start somewhere. These are the types of things we think are important that should be covered. The White House has issued a formal veto threat. The Senate Republicans are generally opposed. There's a lot of scoffing at it as a Democratic wish list or Christmas list. But let's look at the next slide so we have a sense as to what's in there. And I would say from our perspective and what we are hearing, this really represents, I'll call it the opening bid. And like most opening bids, much of this, the end product is unlikely to contain much of these specific items. But this is the opening. Additional funding for state and local governments. And this recognizes the tension point there. There's a lot of states that have been criticized. They were in a deficit situation up until pre-COVID, many because of pension obligations. And now with COVID and the deterioration of the tax base, that has become exaggerated even more. The problem is that the state funds often pay for police, fire, and other funding, critical emergency services. So the funding, the trick there is whether additional funding can be given to state and local governments, not to bail them out for what may have been, what is alleged to be mismanagement before, but to deal with critical emergency services now. The personal stimulus checks, very popular, another round of those proposed. Specific additional hazard pay to key workers, additional relief for rent and mortgage, monies for virus and testing and contact tracing. The thought here is, look, if the federal government's going to say, not our job, states, you handle it, the federal government needs to recognize that no state was prepared or in a position to underwrite that, and that some funding should go along with the transfer of those obligations. That's obviously a very political conversation, as is the question of whether the $600 a week unemployment kicker scheduled to expire in July should extend up through January of next year. There's a lot of people that are being highly critical of the UI program, saying that it improperly incentivizes people for not working, and that we need to have a better system to encourage people to go to work, but to take care of those that can't. So, it's kind of, those are the debate points. The most recent thing is that Senator McConnell, I don't know what he was drinking down in Kentucky over the weekend, but he came back and has said, yeah, maybe we do need some legislation. Maybe we need something. So my little crystal ball says within the next, say, 2 weeks, maybe less, there's going to be yet another round. These points will be jumping off points, but I think you'll see some real differences in the final bill that the president, my prediction is, will sign another round of emergency funding for us. So that's what I see.
David, the one thing I did see most recently is that they would turn the boost in the unemployment benefits to like a return to work bonus. They do some things like that, but I think this is really recognizing when they come back, when the senators came back, that there are real issues in their states that just, the same old is not working because people just can't go back to work.
Correct.
So
okay.
with all of that, yeah, no kidding. So if we could go to the next slide. Now let's turn to what's really going on with the federal agencies that many of us deal with on a day-to-day basis. Maybe not quite day-to-day right now.
Before we get started on that, let me just note, if people have questions, we have a little chat box over there, and I think everyone should have that on their screen by the slides. So just type us a message, and in real time, we will do our level best to try to answer all the questions we get. So that if anyone has that, just type it right in there, and we'll incorporate those.
Thank you, David. I meant to say something about it, then I completely forgot.
Right.
So we are going to start this, going to the next slide, a conversation on the federal agencies with our friends at OSHA, which is not something many of us have ever spent a whole lot of time. Now I was in the coal industry, so that's a whole nother story. But there is in OSHA a duty to provide a safe workplace. And there is the general duty clause, which really all the guidance we're going to be talking about really comes from this clause, which is the obligation of employers to furnish to each of its employees a workplace that's free from recognized hazards that are causing or likely to cause death or serious physical harm. And I would say, David, that a pandemic might fit that description.
COVID-19 fits comfortably.
Yeah. And one of the things that we were talking to some of our clients, they work in offices. They've never done an OSHA plan, and they now are doing an infectious disease prepared and response plan, basically a pandemic plan. Interestingly, we were talking to some people in New York, David, and they were saying that, you know, after 9/11, everybody had emergency preparedness plans, but they all kind of, oh, well, we don't really need those anymore. And many of them had put them aside. And even if they did, this is such a different type of a problem for them to deal with.
And let me just say, Nita,
yeah, go ahead.
Those 9/11 plans were how to get out of your office and building.
Correct.
This plan is how to get into your building. So it's a completely different animal. Yeah.
And I think, you know, there's a lot of, so David, talk a little bit about the issue around the Secretary Scalia and the conflict between him and the Democrats over whether there should be an emergency regulation.
So this is an issue that comes up because this general duty clause, and so the question is, well, is there a specific regulation? Is there a regulation like there's regulations on all sorts of other known hazards and risks in the workplace? How you deal with lead, how you deal with hazardous chemicals, how you deal with any number of, how you deal with saws and sharp objects and ladders and you name it, anything that you might use in the workplace. Well, is there a COVID-19 regulation? No, there isn't, obviously, because we didn't have this hazard until a couple months ago. But the more important question leaning forward is, should there be a new regulation to address this safety and health hazard? The Secretary of Labor, Secretary Scalia, his answer is no, not necessary. Interestingly, in Congress, last week there was a hearing that Senator Graham held in the Senate. And one of the questions is, what about the safe harbor? Should there be a safe harbor for employers? And both Senator Graham, Lindsey Graham, and Senator Klobuchar, Amy Klobuchar, who are not often aligned on much of anything, as you might imagine, both agreed, gosh, it would sure be helpful if we had a specific regulation. They approached it for different reasons, but they both ended up at the same spot. We should have a specific regulation as opposed to a general duty clause that Nita's introduced us to, and we're going to talk about in a moment, these guidelines. A guideline is just that. We all know, we're compliance specialists. We know the difference between a regulation, you have to comply with the regulation, versus a guideline. Don't necessarily have to comply with a guideline. It's a best practice. There are a lot of reasons why you should comply, but it doesn't have the same precedential or compliance obligation that a regulation does. But today, the secretary has said it's going to be guidelines only, and he's buttressed by that by the president issuing an executive order within the last week saying we need to minimize regulations to get business back to work. So I think this in part has become a bit of a justification for we're not going to voluntarily see regulations from this Labor Department dealing with COVID, period.
Right. And I think, David, as we work our way through there, meanwhile, they already have 3,000 complaints alleging retaliation or failure to provide a general duty clause from employees, and we haven't even opened up the country really yet. So employers, to some extent, are going to be protected, more protected if they know what they're supposed to do and then can follow it, than they are in sort of this nebulous never land that we're dealing with right now.
The challenge is to write a regulation that would fit all workplaces, and that's one of the reasons the AFL-CIO has sued the Labor Department to flesh this out. A number of other groups are getting involved. So we're going to have Congress involved in this. We're going to have the courts involved in it. We're going to have the Labor Department involved in it. But for the moment, we do have general duty, so we should be sure we understand what the current rules of the guidelines are. So let's go to the next slide. With that in mind,
with that in mind, David, would you talk about that a little bit?
Yeah, I'm going to just briefly introduce, because I appreciate most people joining us today probably don't have OSHA as part of their portfolio, but OSHA very helpfully has designated, and they've got a pyramid of risk, and this is right out of their guidance that they've issued, from very high risk down to lower risk. Most of us in our office settings are in the lower exposure, lower risk jobs. Some of us may have operations that are medium. That might be retail or high volume situations where you're in contact. The high and very high exposure tend to be medical facilities, testing facilities, mortuaries, things where you are more directly involved with the COVID virus very directly and have to have additional protections and barriers for you. But it is important that there's some understanding and familiarity with this, and that you understand where your workplace setting, most of which, if you're of an office setting, typically you would be in that bottom base category of lower risk, which is less demanding in terms of what protections. Also, and on the next slide, we talk a little bit about what would be required, what the guidance is that's required. There are a couple things on here that I want to really draw your attention to and would encourage you to look at. The first is this OSHA pamphlet. You can tell they don't have very good marketing people. They give it a snappy name called OSHA pamphlet 3990. That's the top bullet there. There's a link, okay? Don't worry. It sounds boring. It's really not boring. This is a really well-executed, and I don't say that often about a lot of OSHA things, but it's a well-executed publication by OSHA, and it, in pretty straightforward language, explains some of the guidance, what the obligations are for different workplaces, different protocols. It's very, very helpful, and you should definitely take a look at it. Second, this is important. Initially, OSHA took the view that most workplaces, certainly those that were lower or medium risk, going back to the pyramid we just looked at, keeping that in mind, would not have to report COVID illness of employees. The thought being, how can you determine whether the workplace was what caused the person to get ill? Now, from the get-go, OSHA said, look, we don't want to be dealing with that. Those that are at the very high or high level of risk, those are at the top of the pyramid that we looked at. From the get-go, the OSHA said, we're going to probably assume if you've got a hospital where the emergency room crew, 25–30% has COVID, or a meat packing plant where you have a high level of people like that, and you contract COVID, your employer probably has an obligation to report that, and there are various ancillary obligations. Now, the OSHA has last week just flipped that around slightly and said that we're going to, in fact, presume that any workplace may have a causal role. And it's going to kind of put the presumption on the employer to demonstrate when an employee got sick that it wasn't because of the workplace. Well, I got news for you. How do we do that? So effectively, in most situations, when you have an employee that becomes ill, you now, in an office or any other setting, you now likely will have an OSHA reporting obligation on that injury. All right. Well, let's talk about some of the other OSHA guidance, Nita, and you can help us with that.
Sure.
Next slide.
Valerie, if you could take us to the next slide. So just a couple of things. I think the most important thing here is OSHA is indicating, and I assume continues to understand, that there will be discretion in enforcement. First of all, they're not going to be doing a lot of inspections. We've talked about that with on-site. In fact, two at least meat inspectors from the USDA have died of COVID. So they're going to have lots of limitations around actually going on-site. And there's going to be discretion, understanding, and I think this is important based on what you just said, David, about reporting illness, the illness reporting obligation. They're going to give discretion to employers as to whether or not they can figure out whether the person really did get sick on the job. And that becomes important, David, something that I think we should just briefly touch on before we go on to EEOC. This whole liability issue and workers' comp. How is workers' comp going to tie in for employees where you don't know for sure whether they got it at work or someplace else? And one interesting thing, there's been a lot of concern, especially among Senate Republicans, about liability against employers as we push to reopen. And I just saw something that the California governor has basically said almost any COVID outbreak is going to pretty much be considered as to be work-related, and you're going to be covered by workers' comp, which for employers should actually be a good thing if it holds up, because at least as to employees, you'd be covered.
Right.
Now, whether
and the workers' comp,
go ahead.
The reason that's so important is A, we can insure for it, and we're under mandatory
Correct.
insurance. B, it provides generally, under most state laws, a defense against various tort claims that people may want to bring,
Correct.
class or individual claims about that they became ill or injured at their workplace. And the answer is you have a defense saying, no, your remedy is workers' comp, and it frankly caps the level of damages and the types of damages that can be recovered. That being said, most states do recognize an exception to that defense for reckless indifference or gross negligence, that type of standard. Where I want to go back, we made the point at the beginning, these are only guidelines. I think that you, though, are in very strong legal position if you can demonstrate that in good faith you complied with the guidelines.
Right.
Therefore, you did not recklessly endanger anyone. You didn't show gross negligence or gross indifference. You complied with the guidelines.
Right.
So that's why, even though they're not regulations, that helps you, and then you can take advantage of the workers' comp safe harbor against potential claims by your employees or other members.
And then that goes back to the point you made at the beginning. You need a plan. You need a plan as you reopen your office.
Yes.
So, David, you want to talk about the last set of guidance we're getting from OSHA before we switch over to our friends at EEOC?
I'll touch on this briefly. Next slide, please. And I just will note so instead of regulations, there's the general guidance, and we pointed you to that snappy pamphlet, the OSHA 3990 pamphlet. But you need to look also, and there will be more coming, but this is the industry guidance that has been listed. So obviously, if any of you have operations or workers that are in these settings, this is a must do. You need to review and be familiar. Right. The OSHA guidance also picks up and is linked back into the CDC general guidance. So we have the CDC that's issued guidance on industry in consultation and conjunction with OSHA. So actually, this is one where the federal government actually has done a good job to help us so that we can go and get sort of one-stop shopping and get the best integrated guidance, CDC and OSHA. Again, not a regulation guidance, but there are some differences depending on, they all have the same basic components, but they're presented differently. And Nita showed us that chart for the workplaces generally. Now we have these detailed writings. Right. All of this information is what you use in preparing your preparedness and response plan that Nita introduced us to at the beginning. So this is something, Nita, I would have to say, of the topics that we have counseled people on over the last 8-10 weeks, whatever it's been, this has been the one where there's been the sharpest learning curve, because most people, particularly in non-manufacturing office settings, just are not very steeped in this, and frankly may not have a lot of muscle memory within their organizations to call on. Right. So this is important. It's a very important area. All right. Well, and I'm going to our next slide. David, another area that I think employers really need to take very close look on is now as you're reopening. So the EEOC took a very unusual step and has sent out quite a bit of guidance on, with the COVID pandemic, what can employers do to find out whether their employees or workers have been sick? Because it's not just employees, it's anybody who comes into your workplace. For example, me walking into David's and Clayton, they took my temperature. So they are allowing, EEOC has said it does not violate the ADA, the Rehab Act, or other laws to take temperatures or ask potential symptoms. Now, one of the big issues here, though, is you still have to keep that information confidential. And David, you were talking about some of the ways employers have done that, and we'll talk a little bit more about that later on. But the other problem that employers need to stay carefully in mind is reasonable accommodation. And now that so many white-collar workers and others have been working from home, the idea of working from home as a reasonable accommodation continues to be there, recognizing that up to a point, employers have an obligation to accommodate for disabilities. They do not have an obligation to accommodate for family issues unless they wish to.
And like when the original ADA first came out, you know, employers have to draw lines as, while they might be willing to give temporary accommodations to people that or might be susceptible, or who have family members who are susceptible, they don't have to do it forever. So that's one thing.
Right.
Go ahead, David.
Go ahead.
Yeah. All right. So one of the things that did happen, though, earlier this month, there was a misstep by the agency. Initially, what they said, what they came out with, in fact, David and one of our other colleagues and I were preparing for a webinar, and they go, the EEOC basically said employers could decide whether or not employees, workers who might be potentially have a higher risk for COVID, that the employers could say, no, we're not going to bring them back. Well, the answer to that is Beulah the buzzer says that is not correct under the ADA. They withdrew it. And this point in the bullet there, generally employers cannot exclude employees or take any adverse action solely, which they emphasize, because they have a disability that CDC identifies as potentially placing them at higher risk for severe illness. And the fact that they are at a higher risk for COVID does not make them a direct threat to their own health. And this goes back to a whole line of cases when ADA first came out, and some under the Section 503 as well. So you can't decide not to bring back employees who are over 65, who have certain illnesses like diabetes and so forth, simply to avoid, you know, as a way to decide that who's going to come and who's not going to come back. There's a lot more there. Thoughts, David, before we go to the next slide?
This is one, and the questions that the EEOC published, we've got a link down to those. This is one where we had a couple of clients, very well intended, saying, well, gosh, we don't want to expose people that are starting to think about how we're coming back. We know who CDC has said is most vulnerable, 65 and older, and you know, all the different situations you listed. So we'll just tell them, stay back, and we'll call others. We're going to go, no, whoa, no, well-intended, but per se unlawful. So the way you can handle that, though, as Nita alluded to, is you can say, look, this is who we want back now. If anyone, you know, reminder, if anyone needs an accommodation, and all of you are very used to and understand the accommodation process, plug and play and consider whether you will accept and accommodate by allowing them to remain home or work from home based on COVID vulnerability, susceptibility.
And in that situation, if they don't have a disability, you can decide to give them a temporary accommodation with the understanding it's temporary and that you're going to look at it at some point down the road. Just a reminder is you need to decide who would do any kind of testing or any kind of doing your assessment of symptoms and so forth. And we'll talk a little bit more about that. David has some good ideas. Next slide, please. Meanwhile, back at the ranch, EEOC has announced that there will be no EEO1 this year. After collecting both EEO1 Component 1 data and the EEO1 Component 2 data last year, they did not get OMB approval to continue to collect Component 1. And I know a number of us were sitting there wondering when they were going to open the portal. So they announced within the last 2 weeks, I guess, David, that they're going to wait and collect it next year. They're going to collect both 19 data and 20 data. I mean, many of you with EEO who already have to do your affirmative action plans, you've already done that. So just hold it off and keep it. The other thing, and I continue to see articles, David, about this, that Asian Americans are being attacked, harassed, and blamed basically for COVID-19. As you bring people back in the workplace, you know, you need to be careful to remind people that harassment's not legal. You want to, you know, that it's not allowed in your workplace. Because the other group that I think may end up being harassed, David, is going to be those people who've had COVID that people know, potentially as, you know, Typhoid Mary type of a situation.
Correct.
One last thing on this, and then we're going to jump over to the NLRB. They right now, EEOC, if you have investigations, complaints pending to the agency, they are not closing the investigations right this minute, because once they close it and issue their right to sue, the people only have 90 days to file their right to sue. And so they, in light of the fact many courts are closed, they are holding that off for the time being. I'm not sure when they're going to start back up. In fact, there's pushback from the federal employees about going back to work into the workplace too quickly. So we'll see how that goes.
Correct.
So,
correct. Yeah.
Taking
right.
the next slide, another area, David, is NLRB, where a lot of people haven't thought about them in, I don't know, years.
Yeah.
Other than those who have unions.
Right, and I think that I think there are 2 or 3 critical points, recognizing that most on this may not have either dealing with labor organizations or union avoidance as part of your day-to-day portfolio. Number one, we're finding that the environment that we're in, particularly employers that are trying to compel people to come back in a situation where employees may not be ready or not willing, where there's concern about their safety, that a number of those workers are looking around and saying, well, wait a minute, what do I do here? I need a counter check to the employer. I'm going to put myself at risk. I'm going to put my parents who I'm living with or my sick housemate, et cetera, at risk. And many are looking to labor organizations, and they're being quite opportunistic and indicating that they're available and willing to help and interested. So there is actually a burst of organizing, including in some non-traditional areas, not just healthcare or some of the areas where we've traditionally seen it, including in the tech sector, where there has not been much penetration, much more receptivity to that now. Second, under the National Labor Relations Act, there's this concept called concerted activity, and that is not limited just to union employees. That is, whenever an individual engages in conduct, it doesn't involve just their circumstances, but the welfare of others, of their fellow workers. For example, Nita says, David, you've got to come back to work. And I say, Nita, I'm just really worried about my health. I've talked to a couple of other people, and we're very worried that the office just isn't ready. You got that old air conditioning system in and the bathrooms and stuff. I don't know. I'm really worried. And you say, well, you need to come tomorrow or you may be disciplined. And the next day, maybe I show up with some of my colleagues and now we're sort of sitting outside. You know, Nita's company unfair. They want us to come back, workplace not safe. That would be classic protected activity.
Correct.
And the labor board has indicated, do not think that just because we're in the Trump administration, Republican administration, this labor board has acted and will act on those types of fact patterns and recognize concerted activity. It can be by one individual simply making comments or taking actions on behalf of other employees, and any COVID-related concerns, more often than not, particularly with respect to the integrity and safety of the workplace, will potentially fall into this protected activity. And what that means is you end up with a hearing, an administrative hearing, and potential to put people back to work, make back pay awards. I mean, there's all that sort of thing. So even if you're not an NLRB practitioner, be mindful that this little animal out there called Section 7 applies to non-union employees and protects that type of activity. All right.
And we're seeing a lot of that. Okay.
Yeah. You want to touch on OFC?
Next.
I know we've had a lot of that, but there's still a few things to cover.
Yeah, there are a couple of things. If we can go to the next slide. David and I had the opportunity to hear from Director Lean last week. And so many of these things Carmen discussed with us as far as the extensions and so forth, data security. On the CSAL notices, and David, correct me if I'm wrong, Director Lean has made it clear he is all over doing contractor verification, confirmation you've done your AAPs. He's still very concerned about that. He is looking for the next CSAL notices to have some type of verification, confirmation attached to it. It wasn't quite clear how that would be handled, but again, as he's often said, he would like to focus first and foremost on those employers who don't do plans, who should do plans. So how that's going to work, we're not quite clear, but just be that's coming. And David, did you want to mention the certainty directive as something that's happening
Sure.
as well?
So in addition to verifications, which will be a big, I think, benefit to all of us on this call who do AAPs
Right.
and who are complying in good faith, who presumably, when we verify, are not going to get audited as frequently, which would be terrific.
Correct.
Second, Director Lean has had his so-called 4 pillars, that's his nomenclature, and one of them is certainty. The others, there has been guidance issued in the form of what they call directives at OFCCP. So Director Lean, who recognizes that his time is potentially running close, has said that he's doubling down on efforts to issue a new directive addressing certainty. And I think that's still being sorted out, what that means, but I hope it means consistency between regions. I hope it means following the rule of law. I hope it means that there won't be these wild variations that many of us have seen in audits and enforcement proceedings, with the luck of the draw being which region you're in. I'm sorry, that doesn't promote certainty. And I think, to his credit, Director Lean has recognized that shortcoming and is trying to shore that up, which is good, Let me just say a word, Nita, if I can, about where Craig's nomination is. He has been nominated by the President, I think everyone recalls, to be the Inspector General of the Office of Personnel Management. That's the federal government's HR department, if you will. And although IGs seem to have a short shelf life at the moment, there are new ones in the offing. And current OFC Director Lean has been nominated. That's a position, in contrast to his OFC position, he has to be nominated by the President. Check, that's been done. He has to be ultimately, with the advice and consent, that means voted on by the U.S. Senate. That's still pending. He's going through the process of meeting with individual senators. That still is underway right now. There is a group of nominations, we're going to touch on that are going to be handled next week. There's a vote. It will pick up some of our EEOC commissioners and get them up to a full complement. Director Lean is not on that, so if you see news reports next week about some new EEOC commissioners and coming up to a quorum, Craig Lean is on a separate track, and they still are going to decide whether they have a hearing and whether he gets bundled with others. So I'd say probably for the next 30 days, we still have Director Lean at the helm of OFCCP. I expect probably by Labor Day, if it's going to happen, it's going to happen about then. But we'll see.
So, David, those are the nominations. That was a late ad. So let's talk about, because EEOC is going to go down. Otherwise, they would be down to only 2 EEOC commissioners. This would add 2 Republicans, Keith Sonderling and Andrea. And then there's one, Jocelyn Samuelson, who's the Democrat, who would be added. That would give them, for the first time, I believe, in this administration, 5 commissioners. And then, in addition, there are two, I believe, maybe 1 Republican, 1 Democrat being added to the board, the National Labor Relations Board. And those are all potted. They're going to be approved by the hearing next week, and I assume be fairly fast-tracked to move on for confirmation.
We expect that. I actually think we're going to see a vote on those next Wednesday, June 3. All indications are that vote, the Republicans have the majority. At a minimum, there'll be Republican support, I think, for all those nominees. Maybe not all of them, but there'll be enough votes to get them through. And it's not expected to be controversial. So that is good news. The EEOC will be up to a full count, as you indicate, Nita, which is very, very important. All right.
So, David,
we're on the quarter-hour mark. Yeah.
Yep. Do you want to talk about wage and hour quickly, and then we're going to go on to legal challenges and for the last 15 minutes or so.
Sure.
Next slide, Valerie,
sure.
please.
So, just quickly on wage hour, there are a whole slew of regulations dealing with the new paid sick leave, paid family leave, Q's and A's, and a number of settlements that wage hour is now promoting and out there. So you should be familiar with that. All of the links are there. One of the other things that I think may not have cut through all the noise is that there are two very important wage hour regulations that we need to be mindful of. The fluctuating work week, which is very important for how a number of exempt employees are paid to maintain the salary basis. Much more flexibility, particularly with respect to bonuses and other premium payments that you want to provide. It will allow you to still take advantage of the fluctuating work week. That's a really important change for many of us. Those of you that are in retail that may be familiar with the so-called Section 7I or retail exemption, there's been an updating of that. It has been expanded, extended, so that even those beyond traditional retail to some non-traditional retail space can now, this is the business-to-business sale situation, can still qualify for this retail overtime exemption. Those are two very positive regulatory developments, updates, and if you have any of your workers that would be affected by that, would strongly encourage you to take a look at those.
So David, just quickly, why is it that they're pushing through these regulations in the middle of a pandemic? Can you talk about that for about a minute?
Sure. Just real briefly, because there is it's called the Congressional Review Act, the CRA, Congressional Review Act. And basically what it says is that when you get a new Congress and a new administration, that you can look back in any so-called midnight regulations, those made in the final days of the outgoing administration, Congress can not only vacate, set aside those regulations, it can also preclude the agencies from engaging in any rulemaking going forward. For example, when the Trump administration came in, there was a bunch of regulatory activities and changes involving, we called it blacklisting, that if you had a bad OFCCP audit, that basis alone, or bad EEOC result, that basis without an adjudication could result in you losing your federal contracts. In that instance, Congress came in, vacated those under the Congressional Review Act, so they not only with the regulations gone, but it precludes any future regulatory efforts on the same topics. What the current administration is trying to do is get its regulations in place and to not have it's preparing for the worst. It is actually assuming there'll be a change in the White House, change in both houses of Congress, and so now the current Labor Department is trying to dig in and protect what gains it can make. So to do that, it has to make sure its regulations don't qualify for that kind of override, congressional override, and that means it can't be done at the last minute. The last minute, this has to be Washington talk, is what they call 60 legislative days. It's not a calendar day, it's not a weekday, it's not a work day. It's this other measurement. It's very complicated, and it ties to the nuances of when Congress is or isn't in session. As a practical matter, it probably means Memorial Day. And so any regulations enacted before Memorial Day cannot be subjected to that immediate sort of voiding by the new Congress. Those that are enacted after Memorial Day potentially could be voided. So you see wage hour being smart and getting their regs out just under the deadline to avoid that type of review. So
David, we've got about, we got about 10 minutes. So Valerie, can we go ahead to go ahead 3 slides? So we wanted to talk briefly about a couple of issues, and ones that I think are, one more, that really are gonna, and for those of you who live here in St. Louis, we saw these pictures all over the national news. So David, talking about pre and post-work COVID-related activities, you know, as employers are sitting here in St. Louis, and possibly some of their employees were down at Lake of the Ozarks or down on Alabama beaches, not wearing masks, not social distancing. What are some of the things you're seeing as best practices out there for employers to deal with situations like this, which is unusual, very unusual? Right.
So normally you think about, we start from the premise that typically what employees do outside of the workplace typically is not the employer's concern. Some exception for your senior executive, CEO, because what he or she does has implications to the company's reputation, so sort of 24/7 they represent the company. But most folks, like those that are enjoying themselves here in the slide, you know, maybe production workers, supervisors in your warehouse, etc., your office managers, workers. Why do we care what they do outside of work? We care because in the pandemic, the question is, should we be screening people? Should we be inquiring about what they were doing to see whether they are potentially, although symptom-free, still contagious? And as we have learned, and the CDC and OSHA have issued guidance, as well as EEOC, that there are a number of basic checks. We note the temperature checks, but also questionnaires. And the questionnaires tend to focus on your non-work activities. You know, is anyone in your house sick or displaying COVID symptoms? Have you traveled anywhere where social distancing was widely not practiced? That would probably pick up if you were down whooping it up down at Lake Ozark on Memorial Weekend. Some employers are asking about international travel. You know, in the last 14 days, have you done this? So there's that type of series, and these are kind of, I call them gating questions as to, you know, kind of yes, no. The temperature checks, the CDC guidance is the cut point is 100.4. I think a better practice is to simply look at whether the person does or doesn't have a positive temperature check and what to do with that. But as employees are looking at how to handle this, some people are using apps, and that employees off of work would use apps. Some people are looking at when they boot up their screen at the beginning of the workday, if they're coming into work, they're working at home, this isn't as critical, but if they're coming into work, that they would go through a series of questionnaires, and if they get flagged, yes, I have a temperature, or yes, members of my household have been sick and I'm here, the computer would immediately flip to a screen that do not work today and issue a set of instructions on how you are to remove yourself. But then the third basic approach is, as people are coming in, and we've seen this at some of the production facilities, where employees are either having their temperatures checked or questionnaires and information is being gathered. And that raises its own set of protocols on what to do about that. What do you do with the information? How do you not disclose it to other employees? And what keys off on this slide is, by the way, if you have people waiting in line, whereas before they could just go through quickly,
right,
do you have to pay them? Do you have to pay them? Are they on the clock? Is it work? Like most lawyers, the answer we would give is it depends. But it depends, and it also depends on which law. Under federal wage hour law, we've got pretty good arguments that may not be compensable. However, under a number of state laws, the answer may be the opposite. So it depends on where the activity occurs. It depends on the duration of the activity. And then if that's the case, it depends on how are you going to compensate it. And there are different alternatives and options for that.
David, there's a fairly complicated record-keeping question here, but let me just throw this out to you. Do you have any thoughts on the record-keeping obligations on temperature checks under the ADA 503 on workplace screening questions, temperature checks at the entrance to the workplace? Is this now physical exam under which, and then is it okay just to screen for the temperature and not to keep a log of those passing through without one, or do you have to log all information and keep it for 2 years?
Right. And there's even another layer that the question doesn't have, which is OSHA medical records. They have to be kept for 30 years. That's 30 years. So let's talk about this. I think that as a practical matter, we don't need to have people's specific temperature. This is a yes-no gating question. 100.4, that is the question. You're either below or above, yes or no. If you're yes, if you're positive, then you are going to take actions to preclude that person in a way that minimizes sharing with others. But if there's some, you can't avoid it. But not broadcasting what the temperature results are, simply telling the person. In my example, I'm running employees through, Nina, would you step over here, please, so we can talk to you further? Mm-hmm. You would step over into a more private situation. The rest of the line would keep having their temperatures checked, ideally with those handheld remote devices, with someone wearing appropriate protective equipment or having a third party do it. my person, Nita, in my example, I say, Nita, I'm sorry, you're greater than 100.4 under our guidelines. We do not want you to work today. We want you to go back home, and we want you to quarantine for 14 days. And I probably would have additional follow-up questions would be the best practice about, are other people at home sick, et cetera, et cetera. There'd be other questions that we would ask about her activity. This is to try to prevent someone who, and a temperature is a rather crude component, but it's,
yes.
There are a lot of reasons why you can have a temperature other than being COVID positive.
Right. So David, we only have 4 minutes. So I thought, let's, Valerie, can we go to the next slide really quickly? We're seeing a lot of people having their pay cut. What are your thoughts around the concerns about having people's pay cut? Sure.
And this is particularly PPP, those that have the payment, you can pay people, but even cut it at 75%, so some people are doing that. Putting aside those business judgments on whether and how much you cut pay, you still have to remember that the Fair Labor Standards Act sets the floor for what the salary requirements are to maintain someone's exempt status. $36,000, $35,568 is the actual amount. And so if you have someone, for example, who makes $40,000 a year and you want to implement a 10% pay cut, okay, you would be right on the cusp, assuming that their duties remain the same, of making them exempt. If you do a 15% pay cut, even if their duties were all exempt, they would lose their exempt status because you would no longer meet the salary test. So this is a reminder, and you have the highly compensated executive also, that COVID is not a license, the response to the COVID pandemic is not a license to override or to ignore these FLSA requirements to maintain exempt status.
Yeah, and the next two slides, let's skip over to Warren. I mean, you also have to, David, worry about reduced schedules and how you're going to handle that, change in duties. And then let's go to the Warren, and let's spend our last couple of minutes on this next slide about Warren. So just to close this out, David, back one, Valerie, if you wouldn't mind. Just to close this out quickly about this, we're seeing large numbers of people are going from being furloughed to being laid off. I know Boeing, for example, in the public press, you're seeing that. So there are many things that you need to take into account, including Warren. I go back to my days at McDonnell Douglas. You have to figure out when you need to give notice. If you have more than 100 employees, you have obligation to provide notice. And even though there is an unforeseen business circumstance that is an affirmative defense, at this point in the pandemic, that may not be enough because you are no longer really laying them off because of something you didn't know. You're laying them off as you learn more about the business going forward. And then Title VII, you can't lay off people because of any protected group. Do you want to lay off people who have disabilities because you don't want to do the health care? You want to lay off older workers because they're more expensive and so forth. Those are all issues you need to keep in mind. And David, do you want to just kind of close this out with your last thoughts on these layoff issues?
Sure. The layoffs, and particularly if you're going to secure releases from people, what we're seeing is the beginning of, and I think we will see much more of a real wave of litigation claims, because these statutes, and there's the Federal Warren Act, many of the states also have their own counterpart state laws that need to be attended to. They have very specific notice requirements to the workforce, to the state agencies. If you want to release, the Older Worker Benefit Protection Act has very specific requirements. Many of you may have used those releases for individual situations, but for groups, 2 or more as a group, you have to give 45 days notice to look at the release. And finally, another point that I think is very important, as you're looking, unless you're using something like seniority, if you're trying to assess and pick and choose who's going to be laid off, or for that matter, who's going to be called back or anything, I just want to put a shout out to think about disparate impact, potential claims. We are working with some clients on that, do it on an attorney privilege basis, but to assess whether those decisions are going to have a resulting impact on any protected groups and to be sure that's what you want to do before you pull the trigger and actually execute on that. So there's a lot going on in the COVID pandemic, and we're finding a lot of people, some of these are just reminders on what people, on the basics. And what's unusual, there's a lot unusual, but one of the things unusual is we have so many legal issues and obligations that makes compliance in this environment really difficult. So I'm hoping this deck, and we'll make sure everyone gets a copy of it, can be at least a useful, almost like a checklist. It's got a lot of detailed citations in it, where to go to get more information, the original sources for you, and we use it as a checklist certainly in our practice.
And David, with that, we'd like to thank the St. Louis ILG for being our host today. There's additional slides here talking about paid leave and so forth. But I think as our time is at an end, we'd like to thank you very much. And if you have any questions, please feel free to reach out. Thank you, David.
Good. Thanks, Nita, and thanks everyone for joining us today. We enjoyed it.
Bye-bye.
Bye-bye.